I now call the second case on this evening's docket. That is case number 117143, State of Kansas v. Jason L. Rucker.
May it please the court, Jeff Leiker on behalf of the appellant. And Justice Nuss, if I could please reserve 2 minutes for rebuttal, sir.
2 minutes is granted.
Thank you, sir. I've only been here a couple of times to argue a case at this level, so I just want to, before I forget, take this opportunity to thank you. It's always awe-inspiring to be here. It's quite terrifying, actually. So I also want to thank you for the several hundred people that you put behind me to root me on.
They're not members of your fan club?
Just, they're there. This is kind of an interesting case, not just because of the issues that it brings before us today, but the way the case got to us in the first place. This was, as I'm sure you've all read, this was a cold case that went unsolved for several years, and then when the technology was available, there was a DNA CODIS hit that led us to the defendant in this case, actually 2 defendants in this case. And the original defendant, Tory Johnson, he was a critical witness in the actual case. He testified for the state, and he testified that he and my client went into the victim's home that night after they were approached by her to buy drugs, and they sold those drugs to her for personal property and sex. The critical testimony from Mr. Johnson in this particular case was that he actually negotiated the deal. My client had sex with the victim, took some of the personal property that was the agreed to the exchange, and then he left. After that time, Mr. Johnson testified in this case that the victim in the case was beaten after she had learned that the drugs that they sold were not good drugs. She became upset. She was beaten and she was raped. And in this particular case, she died. She died in the case, as the court I'm sure read, because of blunt force trauma to the head and when her neck was cut. The defendant in this case, as the issues were presented in this case, is entitled to a unanimous verdict. He's also entitled to a fair trial. And these are quite unique issues in this case because, as the court may have seen before I got here, there was a request to go back and remand the case to get some more evidence in the case because the record, I believe, is somewhat void, and I'll get to that in a second. As far as the sufficiency of the evidence, what the state was required to prove in this case is that a human being was killed and that there was an underlying crime, inherently dangerous crime. In this case, there were several that were listed: robbery, rape, burglary. And the evidence in the case does not show that the robbery or the kidnapping or the rape or the burglary actually occurred. The critical evidence in the case did come from the one eyewitness who says that my client did not participate in any of the crimes, that he was actually gone before the crimes were committed in the case.
Well, my understanding is that witness, in an interview with the police, gave some fairly incriminating statements against your client. Isn't that right?
Well, he did make an original statement that was different. I don't know that he implicated my client into what he was ultimately convicted of. I don't think he ever admitted in his testimony that he was being untruthful. I think at some point down the road, well, he was convicted, I believe, before my client was, and I believe he sent a letter, as indicated in the record, that he was going to essentially tell the truth. And there was some discussion about that between the prosecutor saying, well, aren't you just trying to take the blame? And he never admitted that, essentially. He just essentially admitted that he was going to tell it like it happened.
Counsel?
Yeah.
The letter is not in the record on appeal, correct?
The actual letter, no, there was some discussion on the record, I believe, during his testimony is all I believe might be in the record. I don't know if the letter was made an exhibit or not. I don't believe so.
Okay. So when you mentioned the record deficits, were you talking about the letter?
No, well, I was talking about references he made to the letter during his testimony.
So if we're missing things we need in the record, whose job is it to make sure they're in there?
That's my job.
Okay.
And I guess what I would tell you on that, and I mean, I don't know how much you want me to get into it, but there was a request to get some more information for the record as to why certain things were not introduced at trial, why some of the evidence was missing. And that request was denied by this court for no reasons. I think it was just summarily denied. But that request was made. And I guess I can jump a little bit forward and just suggest that the evidence that was presented at trial was insufficient to show the underlying crimes in the case.
Part of the evidence that was introduced at trial, which is not a part of the record, is co-defendant Johnson's statement to the police, which was recorded and played to the jury. As I understand it, the transcript wasn't made at the time that that recording was playing. But we don't have anything with respect to that statement, and all we have are direct examination, cross-examination, and rebuttal that references that statement, but we don't have the statement. Is that right?
That sounds accurate.
And so how do we reach your sufficiency question even without that statement?
Well,
Because that's what the state relied on in proving its case, is the inconsistencies with his testimony and what was contained in the statement, the initial statement to police. Two different versions of what occurred. Some overlap, but it appears to be two different versions.
right, well, I don't know that I necessarily agree with that last statement you just made. I don't know that it was that much different. There was some implications of guilt on my client originally by Mr. Johnson.
I don't want to get too graphic here, but we're getting down to some pretty significant different recitations of what occurred. One said it was consensual. That's the testament. The sex was consensual. The other characterized it as rape in the interview. There were other conduct that was involved with your client and Mr. Johnson with the victim that was different in the testimony at trial and what he told police initially. And the state used that statement to contradict the trial testimony.
Well, no, I agree with what you're saying. But his actual testimony that he provided in front of a jury to the court was that my client was not there during the crimes, and he was questioned about that on the record. He explained, at least to whatever degree that he could.
But that's not consistent with what was contained in his statement, at least as it seems to come from the direct and cross-examination during trial.
Yeah, I guess I would agree with that they were certainly different. I don't think he was denying that. He was somewhat evasive, and I think the prosecutor pointed that out to some degree. But the only eyewitness in the case testified that my client was not a part of this. In fact, he was gone for most of it. And to get the unanimous verdict, they have to show evidence of every single underlying crime, which was the rape, which was the burglary, which was the robbery. And I think, my recollection was the biggest discrepancy in the statement was that he admitted that it was going to be a robbery from the get-go, and that was a little bit unclear, I thought, from the record, the way that I certainly interpreted it reading it, because as this court knows, I wasn't the trial counsel, was that they had intended to swap the drugs that were bad drugs for the personal property and the sex. And that's what I thought the biggest discrepancy was.
But Counselor, isn't it true that the jury would have had to have taken into account the story that he gave police right off the bat in order to find him guilty? They would have had to believe that story over what he was saying at the day of trial.
No, well, I think they have to consider it. I mean, it was offered as evidence. I think they have to
Right,
consider
that-
it.
Exactly. So, but we don't have it to listen to. We don't know exactly what was said in that statement, although we can assume from how the evidence was presented at trial that they must have put a lot of weight on that.
Well, I'm sorry, was that your question?
Yeah, but
Well, so I don't want to make assumptions. I certainly don't want this court to make assumptions. I want the court to have all the information that they can. And, you know, that kind of segues into the second issue we presented about the photographs. You know, the state complains in their response brief, and I believe rightly so, that there was no contemporaneous objection made to the photographs when they were entered into evidence. And that's why the request was made of this court to remand this for some discussion as to why some of these things were
Well,
not introduced.
not only there's not contemporaneous objections, where are the photographs that you're objecting to? That's not in the record. We don't even know what you're objecting to in terms of what photographs that you're complaining about.
The photographs complained of are, I'm sorry.
We know the numbers, but we don't know without looking at them as to why you find them objectionable.
Well, we find them objectionable based on the description that was, because each of those photographs was introduced as evidence and described exactly what it was. And I believe the repetitious nature of it and the gruesome nature of what was being described inside the photographs was evidence of, I guess, what's being complained of here as to why he didn't get a fair trial. As to, I mean, the case law, there's multiple case laws cited by us in the brief that would suggest that the repetitious nature of those types of photographs, the hog tying of the defendant, her slit throat, the feces on the body, curled up by the bed, and then after showing all these photographs, then repeating everything with the videotape, which was Exhibit 3, I think, is what we cited. That was unconstitutional. I mean, he is entitled by the 14th Amendment to a fair trial, and this
But
court...
how do you get around the fact that we have a statute that requires you to make a contemporaneous objection to the admission of evidence, and you have to be specific as to why you're objecting, when I believe you've said you acknowledge there was no objection by trial counsel? So what else is there to discuss?
I do. I do acknowledge that, and it's not an easy thing to get around, but this court's done it before. When you have issues of constitutional law, this court has taken it upon themselves to address those, even without a contemporaneous objection that's been offered at the trial level.
So is it your position that because these photographs went to the issue of his constitutional right to a fair trial, that we can disregard KSA 6404 and move right to the merits?
To ensure his fundamental right to a fair trial and due process, yes, I believe that you can't disregard that. That's what I'm offering anyway.
Counsel?
Yes, sir.
You indicated there was no objection, but wasn't there a stipulation that they were, by both sides, that they could be admitted?
Yes, there was. In this particular case, and this was unusual when I was reading it, just as I imagine it was unusual to you, but one of the very first things that the prosecutor and the defense counsel did was agree these are the exhibits that we're stipulating to. And then after the trial, after the fact, the same trial counsel complained of those same pictures being offered, which was obviously very confusing to everyone. I don't think it changes the fact whether or not he received a fair trial, that she waited until that time to offer that particular objection. But that's what happened. That's what this court's left with. That's what I'm left to talk to you about today, is that I think just further evidence to show he did not get a fair trial when you have counsel giving these exhibits to the court in the first place, and then after it's over saying this was completely egregious, the jury should have never seen these things.
That sounds more like an ineffective assistance claim. Let me just make sure I understand what you're driving at on sufficiency. So there are 4 potential underlying crimes for the felony murder, right?
Yes.
And you're not contesting that there was proof of each of the elements of those crimes committed by someone. You are just contesting the link to your client. Is that right?
It is. You know, I think that there has to be a causal connection regardless of the underlying crime and the murder itself. And the testimony and the evidence that was presented at trial is that my client was gone, you know, even before the robbery happened. I think the testimony was that he had sex with the defendant, which was consistent with the DNA evidence. I'm sorry, had sex with the victim, which was consistent with the evidence. And then after that, he left with the TV, and according to the only eyewitness, these other things happened and she died.
But that's cherry picking the variety of stories, right? Cherry picking that they made a trade that made the sex consensual, and then he left with a TV that was also agreed to, that he could take that as part of the payment for the drugs. Is that right? I mean,
That's our position, so.
yeah, okay, I just wanted to make sure I was clear on what your position was. That's it.
Terrific. I don't know if that's cherry picking. I just don't know that I agree with the assertion that the original statement was that much different than what he testified to at trial, which was the only evidence that was offered to explain how these events unfolded. So I guess maybe that's where our discrepancy is here.
Okay, thank you.
Thank you.
Do we have any further questions of counsel? All right, thank you, counsel.
Mr. Chief Justice, Associate Justices, Counsel, from the get-go, it was a plot for robbery. These are the words of the co-defendant, Torrey Johnson, in his testimony at the trial of Jason Rucker. Your Honor, the two issues that are presented before this court today of sufficiency of the evidence and of erroneous admission of photographs, I would submit to this court, do not present complicated questions of law, but they do involve questions of fact. Based on the questions of the court, I think that the main contention here is perhaps the record isn't sufficient to support the convictions, or perhaps the court cannot get a full picture based on the record before it. To briefly go through the facts again, on or between October 19th and October 22nd, 1997, Vicki Ernst, who struggled with drug and alcohol problems, was murdered in her home. The condition in which she was found was that her home was ransacked, jewelry box left empty on the floor, upside down, drawers opened, apparently gone through. Vicki herself was found on her bed, hogtied, her feet to her hands, to her neck. She was naked from the waist down. Her own excrement was near her. Near her also was her jacket, on which later was found the defendant's semen. Also, under or near her was a quilt also containing the defendant's semen. This case went cold for a number of years until a CODIS hit allowed officers to realize that two people, specifically Torrey Johnson and Jason Rucker, were in that house. Their investigation led them to interview Torrey Johnson while he was in custody in Missouri, serving a life sentence for murder. The statement he gave to police was the critical evidence which the state relied on in charging and convicting the defendant, Jason Rucker.
Counsel, there was additional DNA seen, right? From two other men, one a boyfriend and one unknown.
Correct. The boyfriend in this case, Celestino Zavala, he cooperated with police, although he was initially a suspect. He is the one who, in fact, found Miss Ernst in the condition in which police found her.
And the other DNA was never identified to anyone?
I believe it was only identified as that of a male.
Okay.
Based on the statement given by Torrey Johnson, the state filed felony murder charges against Torrey Johnson and Jason Rucker, alleging 4 alternative means for the underlying felonies to support felony murder, to wit, aggravated burglary, robbery, rape.
Kidnapping?
I'm sorry?
Kidnapping?
And kidnapping, excuse me, yes.
In such a case, what level of proof is required with respect to the two-wit,
With respect to the two-wit,
to the underlying felonies?
at the trial level, it is in all states. The state has to prove all elements beyond a reasonable doubt. On review, the court looks at these 4 alternative means, since we did not elect which specific mean.
Sorry to interrupt. Is it the state's position that the state had to prove that each of those felonies was committed fully and completely? Because that's not what felony murder statutes.
No, it's not. That's not
That's
our
one
position.
thing that has confused me about this case.
Yes, I'm sorry, Your Honor. And the jury was instructed properly on felony murder law that the killing had to have been done while the defendant was attempting to commit, committing, or in flight from an inherently dangerous felony.
So you don't think the state had to prove every element of each underlying felony?
I do not, Your Honor. And there was also in this case, given the aiding and abetting instruction, and I think of great importance on review, is the mere association instruction. Mere presence of the defendant while these crimes were committed is insufficient to appropriate criminal liability to them. The jury heard that instruction in conjunction with all the other instructions. So they know from the get-go that it's not just a matter of the defendant's there and all of these horrible things happen to Miss Ernst. They have to find that he's an active participant, although, albeit that can be a very small degree. However, given the state of her house and the fact that the defendant's seminal DNA was found near Miss Ernst, and given the statement of Mr. Johnson, all of those crimes, you can make a very good argument, as the state did, that they had been or were in the process of being committed. I think
There wasn't any specific testimony about length of time either, was there? It was just, I mean, this all happened in some undefined amount of time, right?
that's a fair assessment of the testimony, Your Honor.
Okay.
It begins, Tory Johnson's testimony at trial changes. It's much different from his statement to police, and that comes through in the transcript, I think. What does come through in the transcript also, the prosecutor gets out the key statements affirming that Jason Rucker raped Vicki Ernst, that he dragged her from one room to the bedroom, and also that he was the one who actually took the television, and all of those are sufficient to support the underlying felonies. And on review...
There's no question, though, from the evidence, depending on Mr. Johnson's earlier statement and later statement, that Mr. Rucker had anything to do with the killing. Is that correct? Actually, the physical act of killing.
No, there's no evidence that he is the one that actually either bashed her in the head with a hammer or slit her throat. But that is not required, of course, by the felony murder statute. He just has to be an accomplice in these underlying crimes.
Both of those stories from Mr. Johnson had a third man there.
Yes, from the record, I'm understanding that they pronounced his name Jesus rather than Jesus, because it seems like that's a question of fact, like they're asking Jesus or Jesus, and it's spelled identically in the transcripts. There's not much more given about that character.
Well, what's given about that character is that he was the one that did the killing.
Correct.
That's correct. And where in what we have could you point to that he was involved in each of the underlying felonies? Because isn't that required?
That Jesus was involved in the underlying felonies?
Yes.
I think you can take Tory Johnson's statement. Well, first, we're not
We
even...
don't have Tory Johnson's statement, so what we have are little bits and pieces here that we would piece together. If we get to that question, what do we have that he was involved in for instance, the rape? How would we deduce that from the testimony that was deduced from him from the direct examination and the cross-examination? It's pretty sketchy on that particular question.
I agree. I don't know that the state has to prove that Jesus or Jesus had anything to do with the rape itself, since, well, we don't really have, I think I agree, we don't have any evidence that he participated in the commission of the rape. You can get rape from the statement of Tory Johnson implicating himself and Mr. Rucker, but I do not believe that as a matter of law the state is required to prove that Jesus, if he even did exist, was attempting to, and I'm not making a pun there on the Galilean of renown, I want the court to know.
I understand.
Even if he did exist, somehow was participating in this. The evidence is sufficient to show that Jason Rucker did participate in the rape and murder.
So I'm sorry, are you saying there's no evidence that this Jesus was ever there?
No.
That it's a made-up?
I don't want to say there's no evidence because, of course, you have the testimony and the statement of Torrey Johnson saying that he was. There's no forensic evidence or any other independent evidence, I think, that you'd be able to link him to that. He's more or less a ghost in this story. It'd be interesting if the court had the kite, the prison note between Torrey Johnson and Jason Rucker. I think it comes through in the trial testimony, but that is quite clear in that kite that he's trying to set up a story, that Torrey Johnson is trying to set up a story whereby if he testifies, it will exculpate, it will completely exonerate Jason Rucker to the point where he was just a mere bystander. He didn't have anything to do with these underlying felonies.
But doesn't the state have to prove a causal connection between the underlying felonies or attempted felonies and the death?
Yes.
And so if the individual who the only evidence suggests is the one who actually physically committed the homicide is, in your words, a ghost in the story, does that give you a problem in terms of causation?
I don't think we need to define the precise cause, Your Honor.
Well, what did you have to prove here in terms of causation?
In terms of causation, that the evidence supports that Vicki Ernst was killed in the commission of attempt to commit or flight from these 4 inherently dangerous felonies. And I think that even without this ghost character, and I mean, he might well exist, I'm just saying the only basis for his testimony lies in Torrey Johnson's words.
His existence. The only basis for his existence is his story. He was supposed to have hit her with a hammer before she ended up in the bedroom, right? And then the slashing came later.
He was responsible for those acts, and I don't remember the precise timeline, Your Honor.
I think what the testimony was that one took place at one time and then the
Yes.
second assault.
I think the hammer blows preceded the slashing, if I'm remembering correctly, but the record will correct me if I'm wrong on that point.
Counsel, there's been some discussion kind of dancing around the main issue, and I want to get to the main issue just so I'm clear on what your position is. The issue is, according to the defendant, there's insufficient evidence to support the conviction of felony murder. Tell me what evidence there is that is sufficient to support it.
Nothing in this whole case, from the finding of Vicki Ernst, the position she was in, nothing indicates that this was a consensual transaction, whether it was for drugs, in exchange for television and sexual favors. That was the story that was presented at trial. So the jury had to make a credibility decision. What precisely do they believe in Torrey Johnson's statement? And when the evidence they're presented with, this gruesome crime, which is before their eyes, nothing indicates that this was an accident, that this somehow was not done in the commission of these 4 felonies. Does that come close to answering your question, Your Honor, or can I get more specific?
Can you relate this specifically to Mr. Jason Rucker and why he would have sufficient evidence to support his conviction for felony murder?
Based on the testimony at trial, based on the evidence presented, he was an active participant in these 4 underlying felonies. The state, in the brief, it walks through the record sites for how he actively participated in those. But the law does not have to require us to prove that he is the one who felled the hammer blows or slit the throat of Vicki Ernst. It's clear he was present, that he was an active participant, and that Vicki Ernst did not survive after his involvement.
And just so I'm clear, are you saying that there was sufficient evidence for all 4 of the underlying felonies that were alleged?
Yes, Your Honor, with the evidence that was presented at trial, with the exhibits which the jury viewed, with the statement which they reviewed as well, taken all these in totality, that evidence was indeed sufficient. And the argument, the defense that was presented at trial was not that these horrible, atrocious acts against Vicki Ernst didn't happen. It was merely that he was a bystander. The jury heard Tory Johnson's version of events that he testified to at trial, and it heard the fact that he was in this kite. He refers to Jason Rucker as his blood brother. And if I can quote the court what was said, what the record does present us with that letter, it's not the words of someone who is actually trying to help out an innocent man. Bro, I love you. I got a blood brother. But me and you are blood brothers. That's how much I love, and I don't want to see you get caught up. If they don't get one of us, let them come get me. The only way I see you getting out of this is to put it all on me. And he also talks about the letter advising him they're both going to plead the fifth. The plan was to pay for sex, and then Tory himself trips. Jason leaves, and Tory puts her down. So he's offering right there to put the murder all on himself. That is highly impeaching testimony. That's not evidence that you need to send to an innocent man that had nothing to do with this murder. That is a cover-up. That is a way to get this co-defendant, his blood brother, out of the charge of felony murder. And Tory Johnson was up front. He's already serving a life sentence. He doesn't care what happens to him.
You're just saying that all the evidence, which is mostly, or the circumstantial evidence about the connection between the felony murders and the homicide is sufficient for a reasonable juror to believe the state's version of events. That's basically what your argument is.
Yes, Your Honor, and circumstantial evidence is weighted precisely the same on appeal as direct evidence, and the court does not engage in reweighing evidence at this stage. I don't have time to address the second issue unless the court has any questions that I can answer on either issue.
We've taken a lot of your time with questions, as I've done for other counsel this evening. If you would like about 60 seconds to wrap up or to include discussing these photographs, it's your choice.
Thank you. Your Honors, the state's position on issue 2 is that first, it's not properly before the court because we do not have a sufficient record for review. The photographs, furthermore, were stipulated to at trial. Therefore, we can't even overcome that procedural hurdle. And I believe counsel briefly made an argument, more or less ineffective assistance at this point. That is not properly before the court in this. As you'll read in the state's brief in State v. Pennington, it lists the very few occasions which this court has found photographs to be so gruesome or repetitive that it basically causes prejudice to the defendant. And we do not have those photographs before us. Those photographs concern autopsies when you're looking at the organs. Even in the brief, we do not have that issue before us. In sum, I would ask this court to affirm the conviction of Jason Rucker for felony murder based on sufficiency of the evidence supporting all 4 of the alternative means, and also based on the fact that the photographs did not deprive him of his right to a fair trial.
Any more questions? Thank you, counsel.
Very briefly, I just want to follow up on a few points that I heard. There was some discussion very early on when the prosecutor was up here talking about the gentleman Zavala, the boyfriend. I believe his DNA was actually found on the CODIS hit when they did the DNA testing on the victim in this case, and there was also testimony that he had a pretty tumultuous relationship with the victim. I believe that my recollection of the transcript was that one of them, the victim or the boyfriend, may have been shot because of prior domestic violence between the two of them, and she said that if I ever end up dead, this guy did it. In this case, the state does have the burden to show that causal connection and evidence of all 4 underlying crimes, not just 3 of them or 2 of them. It has to be all 4 of them to get to where they want to go in this particular case, and that being a conviction for first-degree murder. At no point do I believe, based on what we know from Mr. Johnson's communications to my client during the trial, that he was going to take the blame for this. He wasn't at all saying that he was going to be dishonest. I don't think there was any reference to him lying for anybody. His reference was, this is what I'm going to do, and I love you. the fact that the court doesn't need to interpret these facts based on the light most favorable to the prosecution is not lost on me. I understand that, and I understand the struggles because of, some of the giant holes that are in the record here. I can't really offer, I guess, an excuse for that. There was a little bit of paper filed before I got here today to try and help add to that and some of the deficiencies there. And the record is incomplete, I do believe. I think that the court does need to look at the evidence that was shown, the evidence that was just relayed to us by the prosecutor, and see that the evidence was it was very weak on most of these offenses. There was some evidence, I certainly acknowledge, that was offered for, like the rape, for example, the DNA that was found. But to get to the point that that was in fact a rape and not a consensual act before all this went down, before the victim found out that the drugs were bad and became angry and got into the fight with Mr. Johnson, that evidence was not shown. And so because we don't have any type of uniform verdict and unanimous verdict for the 4 underlying crimes, that's the argument. That's why we don't believe we can get to the first-degree murder.
Do we have any further questions? All right. Thank you, counsel.
Thank you.
We thank you both for your arguments this evening. The court will take this matter under advisement.